let's talk about that, okay, which really has to do with whether, quite frankly, whether you have pets, whether you have whatever you've got, okay. You are correct in this sense, that when you die, nobody automatically, just because of your death, has a right to be going into your home, okay. If you had it jointly owned with somebody, then they would be able to do that. But legally, how does somebody come about having that authority, if that's the issue that you're looking at? One way that you can give that authority is through a will. Okay, and let's spend 1 minute on talking about wills and how wills work, I guess, so we know that. What do we really do in a will? Let's think about it from this standpoint. Here's the kind of stuff that we do when we talk about having wills, okay? In a will, what do? We talk about what we own. We talk about who it's going to go to, okay? And we talk about who's going to be in charge of that. So in my will, I might talk about my house, I might talk about my collections, I might talk about my pets, I might talk about all these different things that I own. And in that will, I'm going to talk about who are they going to go to. So one of the arrangements I'm now talking about is perhaps my pet is going to go to my brother. Maybe that's the arrangement that I've got under my will, is to do something like that. As well as where my house is going and all those other kinds of things. What you're kind of talking about is who's going to be in charge of that, who's going to make sure all that stuff happens, and that in Michigan is what we call a personal representative. Some states call it an executor, here we call it a personal representative. That's the person that you name in your legal document, your will, to basically take charge. In that case, it would be your personal representative that would have the legal authority to be going into your home, to be taking care of your pet, to be taking, doing all these things that you want to do. The problem from an immediacy standpoint, if that's the issue that we're looking at, is this will that you prepare doesn't do you any good until a probate estate is opened. So a will, a lot of folks mistakenly think that wills somehow avoid probate. Wills do not avoid probate. All a will does is says, once my probate estate is opened, we'll talk about probate, once it's opened, then the person I've named in my will, I want them to have the legal authority to take charge of my assets and do all those kinds of things. So kind of the problem with the will from what you're looking at is a will is not immediate. It doesn't give anybody legal authority to go do anything immediately to do something. It can be an effective part of an estate plan. I'm not saying that we shouldn't have wills, but it's not addressing that issue in particular that you're looking at. Where wills kind of fit in, I think, as a strategy, and that's what we really talk about as estate planning strategy. Wills, they don't avoid probate. So if your estate planning goal is to avoid probate, the will doesn't do that for you. In our wills, though, we do nominate the guardians for minor children, very important. So somebody who's going to raise our children, okay. We can, under our will, nominate who is going to be taking care of our pet for us, but it's not an immediate kind of thing that we're looking at doing. And we're going to talk about why a trust might be a better arrangement than doing something like that. Sometimes clients will look at me and they'll come in thinking, I have to have a trust, I have to have a trust, and by the time we get all done with it, it really doesn't make sense for them. Wills are less expensive, okay? Trusts are much more expensive to do. So it all depends upon what you're looking at trying to accomplish. If it's okay for your estate to go through probate, if there's nothing immediate about that needs to be done, then wills can be an appropriate estate planning tool as part of an overall estate. But in the situation that you're talking about, Tom, will doesn't do that. The better arrangement, actually, to address your question, would be, is there an arrangement? Is there some legal arrangement out there where the moment I die, somebody automatically now has legal authority to go into my house to take charge of it? And that's going to be a trust. Okay, we'll talk about pet trusts in a moment, but let's talk about kind of trust in general. I'm just going to stick this over here if that's all right. Remember to take it down. Okay. Different kinds of trust, all right, in the big picture, all right. There's what we call a living trust, and there's what we call a testamentary trust. A living trust is one that you create during your lifetime. A testamentary trust is part of your will. Now, in trying to address the concern that you have, the problem with the testamentary trust is because it would be inside your will, it's not going to give anybody any legal authority until a probate estate is open and we still have that same time delay. The living trust, though, is what we create during our lifetime, and it becomes effective during our lifetime. So the moment that it is created, it now manages things for us during our lifetime. Two sorts of living trust, too, that we can look at having. We can have a revocable living trust, or we can have an irrevocable living trust. Revocable meaning we can change it. Circumstances change, families change, things change, we can change it. Irrevocable means once we create this thing, it can never be changed. Most clients, when they look at having a living trust, have a revocable living trust. The irrevocable that you can never change normally is going to be some sort of a federal estate tax planning strategy where we've got federal estate tax planning issues with clients. It might be part of a Medicaid planning strategy. So it's a very unique circumstance. So what we're going to talk about is that revocable living trust. Okay. Just like that will over there, with our revocable living trust, we're going to talk about what we own, who gets it, and who's going to be in charge. Now, the terms when we're talking about having a trust, we have what we call a grantor. The grantor is a person who creates the trust, not the lawyer. If you had a trust created for you, you would be the grantor. If it was a husband and wife, they might have a joint trust. They would be joint grantors, but that's who has the trust created for them. Okay. Second term that we look at is the trustee. The trustee is the person who's in charge of it, who manages it. Well, for most clients, they are going to be their original trustee. So they'll have a trust created, they will be in charge of it. Then what we actually plan for is who's going to be the trustee when they can't, i.e. when they pass away or become incapacitated, who now can step in and manage whatever is in their trust. And the third designation that we look at when we have a trust is the beneficiary. That is, who gets the benefit of whatever this trust arrangement is, who benefits from it. Again, for most clients, they're going to be the original beneficiaries. And we're going to talk about who gets the benefit of this trust after they pass away. So part of the planning for all of that is who's going to be what we call your successor trustee, who's going to step in and do these things, and who's going to be the beneficiary ultimately at the time of your death. Now, getting to Tom's question in particular, if we create this trust, and for example, we put our home inside the trust, let's use that as an example. What the trust normally then says is when I die, immediately upon my death, the successor trustee now has the legal authority. Exactly that legal authority you talked about. The moment that I die, that successor trustee now has the legal authority to enter my house, to take charge of my assets, to take care of my pet, to do whatever needs to be done. So that is the most immediate way to give legal authority to somebody else to be able to do something for you. We don't have to go to the probate court because a trust doesn't get filed with the probate court. We're not dealing with any time delay. So if we're looking at the immediacy in your situation, having that trust is the arrangement to do that. Additionally, what that trust normally says is if I become incapacitated, and we can define incapacity in our trust documents, once that happens, my successor trustee can step in and manage as well. The real difference is in the event of incapacity, my successor trustee is stepping in, managing that trust for me, all right, because I don't want giving my estate away once I become incapacitated, but it allows them to step in and manage it for me because now I can't take care of it myself, and at the time of my death allows them to step in immediately to take charge of all my assets. So if you had a living trust, in your example, your successor trustee, the moment you passed away, would have full legal authority to go into your home, to take charge of your assets, to take care of your pets, to do whatever it is that needs to be done with respect to managing your estate. Does that make sense anyhow? So if that's the issue, if that is an issue that we're looking at, that's the way to handle that, which would be a living trust. Let me just continue that thought. Now, a lot of, when we start talking about planning for our pets in particular, we can have, as I said, under Michigan law now, a trust for our pets. And since we're talking about trust, we might as well kind of talk about how that would work in kind of two ways to look at having a, what we would generally refer to as a pet trust. I can create a totally separate trust, totally separate legal document in which I'm going to talk about what's going to happen, how are things going to be managed for my pet. Or what I can do is I can simply incorporate into my original trust provisions for my kids. Okay? So we can do two different things.